I talk to lawyers from other states about jury shuffles, their eyes roll over the back of their head. They have no idea. What? You get to do what? So, now let's talk about the meat of deselecting a jury. Identifying those people that you're starting to get the impression from, you're starting to get the idea about their life experiences not being compatible with your client or the facts of your particular case, regardless of what type of case it might be. And most of what I'm saying translates to criminal trials too. The purpose should be the same. Some of the law, most of the law is going to be the same for criminal trials. Little nuance differences. But for the most part, what I'm saying applies to criminal cases as well. So keep in mind that bias and prejudice are extremely legal terms, extremely important legal terms for us in the legal field. And for decades and decades, there were scant opinions, hardly any law whatsoever on Voir Dire. The rules of civil procedure gave incredible discretion to a court on handling the trial. That includes Voir Dire. Even though you look at the rules of civil procedure, you won't find Voir Dire. So for decades and decades, one of the only couple of cases out there said, starting back in the 60s, confirmed again in the early 80s, if a panel member says something that indicates that he or she is biased or prejudiced, they are disqualified as a matter of law and they cannot be rehabilitated. For decades and decades, that's the way that lawyers and judges operated. Somebody said something that would indicate a bias or prejudice against the client, the case, the facts, they're out of there automatically, period. Judge cannot come back and rehabilitate them. Other lawyer cannot come back and rehabilitate them. It's done as a matter of law. And then in 2005, after decades of silence, the Texas Supreme Court comes out with a case called Cortez. It's a nursing home case, a tort case. Any of these cases that I'm referring to are cited in the paper. Cortez says, hold it, wait a minute. The paper that I have 10 copies. I think they're going to make other copies for you. Cortez came out and said, wait a minute. You know, we realized that there was a panel member that says he was a defense lawyer. And most of the cases he saw really didn't have merit. And that he had an inclination himself in the way he viewed these cases. And it was against the plaintiff. And the defendant would probably start out ahead. Well, up until Cortez, that guy's gone. Disqualified as a matter of law. Cannot be rehabilitated. Cortez came out and said, you know, at first blush, you can't just accept initial statements and presume bias and prejudice. The life experiences and statements need to be explored. Even if there is something that indicates a slight inclination toward one side or the other, that's not necessarily good enough. And the opportunity for rehabilitation should be allowed, whether it's by the lawyer or even by the judge. So all of a sudden we have decades, truly decades of law immediately turned upside down because it was a major shift in Voir Dire. Because now you've got the ping pong effect. Now somebody says something that indicates even clearly that they're biased or prejudiced. And the way that this generally works, not every court, but the way that it works is that you address the panel, the other side addresses the panel for the 30 minutes or hour. And after that, the panel is dismissed out in the hallway for a break. The judge will say, lawyers, do you wish to question anybody individually? Further questioning. individually at the bench. Yes, Your Honor, I have a question about what panel member 4, 12, and 17 said. Other lawyer may say 3 or 4, and he'll have the judge will have the bailiff bring one panel member at a time up to the bench, and each lawyer will get then to ask additional questions, trying to rehabilitate, either trying to continue to disqualify or rehabilitate that person. And how many times have I heard the general throwaway question by a judge? Well, we understand what you said, but will you listen to all the evidence before you make up your mind? Will you be fair to both parties in this case? Can you be fair to both parties in this case? The judge, sitting in an elevated position, in a black robe, looking down, is going to always get the same answer. Yes, Judge, I believe so. I think so, Judge. And now, a lot of times, that's good enough. And regardless of what else that person has said, they may well end up on your jury unless you utilize a peremptory strike. And that's what we're all talking about in this process right now, is trying to get the judge to disqualify a person so you don't have to use one of your 6 peremptory strikes, because you only have 6. And if you've got a panel of 36, that doesn't go very far. And keep in mind, the first 12 left over after you use your 6, and the other side uses their 6, and the judge disqualifies whoever he's going to disqualify or whoever she's going to disqualify as a matter of law, first 12 people left over get the jury box. So that's why it's incredibly important to understand that you need to disqualify people as a matter of law if you sense an inclination against you, your client, your facts. You need to walk them out. Something as a tidbit, because there are about 4 to 5 Texas Supreme Court cases that have come out since 2005, starting with this Cortez case. All of a sudden, Voir Dire is the hot topic. After decades and decades and decades of never even writing on it, we have a couple of Court of Appeals cases. All of a sudden, the Texas Supreme Court is extremely interested in Voir Dire and is getting us as a state much, much closer to the federal Voir Dire system. Basically giving the judge almost unlimited discretion in determining whether a person, regardless of what it said, how much bias or prejudice, inclination toward or against one side or another, is allowed to sit on the jury. So knowing that, it's so critical to know that you have to walk that person as far as you possibly can. The court has said in the cases that have come out, these 4 or 5 cases, and I'll touch upon these in just a moment, but generally, the more information you give as a lawyer early on in the Voir Dire process, keep in mind it's not opening statement, but you're still allowed to give a thumbnail sketch of the case, of the facts. The court has said that the more information about the specific facts of the case are given early, the harder time the lawyer is going to have disqualifying that juror as a matter of law because of perceived biases or prejudices. If you get their information, their feedback, their answers, that is as free of the facts of your case as possible, then that shows a stronger inclination to be biased or prejudiced. The more information you feed to them, you're helping to build in bias or prejudice. You've got to read the cases carefully to get that information from the Supreme Court. But to a large extent, that's what they're saying. Tidbit number 2, which you won't find in any of these cases. If you bring panel members up to the bench for individual questioning, because you've got a very serious concern about their inclination, their bias or prejudice for or against you, plaintiff or defendant, put things on the record. First of all, let me back up. All of this should be on the record. A lot of times, there won't be a question. Judges like to protect their court reporters. A court reporter, one of the most difficult things to do is, guess what? Take down Voir Dire. It is a pain in the rear end. I have had judges attempt to intimidate me when I've said, Judge, you know, we're going to need this on the record. You really need this on the record? Give it a shot. All right. Get the court reporter, leaving nothing to the imagination about how he feels. And when the court reporter comes in, all huffy, there's nothing left to the imagination about how the court reporter feels about this. So don't feel like you're going to make a lot of friends. You're also not going to make a lot of friends with the jury shuffle. Well, I've had bailiffs get so irate with me asking for a jury shuffle because it's a pain. But you've got to be thinking of your client. As a young lawyer, you're going to be subject to some intimidation. Let's be real. But you've got to know on some of these things, you've got to stand your ground. And the court reporter gets paid by the state or the county. And guess who else gets paid? The bailiff. And this is your right. Take advantage of it for your client. So, if you're in a situation where you're bringing somebody up to the bench, another little tidbit that's not in any of these cases is to put on the record, well, something like, now, Ms. Jones, you know, when I was asking you these questions about my client and the facts, some of the facts in this case, the type of claims involved, I saw what I perceived to be some type of frown on your face. Mr. Smith, you know, when I was asking you earlier about the damages in this case, I noticed that you sort of rolled your eyes, and I appreciate that. You know, I appreciate you being honest and sharing your true feelings, but putting some things like that on the record, guess what? The Court of Appeals doesn't have a clue what Ms. Jones or Mr. Smith looked like, acted like, what their inflection of voice was. None of that. So when you have an opportunity, without embellishing, you've got to be a little bit careful. This is a little bit of a fine line. You don't want to embarrass the panel member who could end up on your jury. Because as bad as they might be, you might have 6 others who are even worse. So, just a little tidbit. Let's go back to some of the law. Cortez, 2005, all of a sudden, yes, you can rehabilitate. And if anything, the Texas Supreme Court says you're encouraged to. Now keep in mind, and we're not going to get into a political discussion, but since the late 80s, starting in 1988, we've had a transition to an extremely conservative Texas Supreme Court. Nobody will dispute that, regardless of what your political ideology is, whatever your background might be. That is basically almost a universal truth here in Texas. Everybody acknowledges that. And so that's been part of this transition. 2006, Hyundai comes out, as in a car. Hyundai involved a products liability claim about the airbag coming out and with such a force that it kills a 4-year-old girl in the front seat. Suit was brought, and the plaintiff's lawyer knew he wanted to ask the panel about a particular area. Would it make any difference to you if the evidence in this case indicated that baby Sylvia was not belted in? Would that have any effect on the way that you viewed the evidence? Would that make a difference to you? Well, guess what? Yes, absolutely. Are you kidding? Stricken, stricken, stricken. And the term is busting the panel. Panel's busted. Second panel brought in, this is in a Houston court. Would it make a difference to you if baby Sylvia was not belted in? Would that have an impact on the way you view the evidence? would you still be able to listen to all the evidence and return a verdict in the plaintiff's favor, even if the evidence showed that she was not belted in? Are you kidding? Get out of here. No way. Busted the panel. Again. Third panel comes in. These people were just being honest. They were telling their actual feelings. Ms. Jones, would it make? Hold it. Counsel, approach the bench. We're not going to go into that. The judge, we're not going to have it. You're not going to get into that line of questioning. Well, how do you feel about products liability? Panel wasn't busted. They didn't know until they heard the evidence, actually until opening statements. Guess what the result was? Case was appealed. Texas Supreme Court said the court has discretion. And commitment questions really shouldn't be asked, because that's the equivalent of a commitment question. The lawyer is attempting to commit the panel member to a particular position based upon the facts of that particular case in advance of any evidence being put in. So, no, the judge has total discretion. As a matter of fact, the judge should not have allowed that. Okay? Now, I can tell you, as a point of personal privilege, since the Texas Constitution says that both parties are entitled to a fair and impartial jury, with the Texas Constitution, I've cited in the paper, fair and impartial jury, constitutional right here in Texas. That's a perfect example of getting truthful feelings and information out. And guess what? The proof is in the pudding. They lost the case. So it was also evident that they might have had to go through who knows how many panels in order to get the jury. To me, it sort of begs the question of, does it really matter how many panels you have to go through in order to get a fair and impartial jury? All right, I'll get off my soapbox now. I hear the Battle Hymn of the Republic playing in the background. So, another big sea change in Voir Dire. Yes, the judge has always had significant discretion in conducting the trial, that includes Voir Dire, but now we have Supreme Court pronouncements that now rehabilitation is not only allowed, but almost encouraged. And you cannot commit a juror by asking these questions that you're going to find out how they feel about the facts in advance of the evidence. But yet, when they're in the jury box, if that's the first time, there may be some real problems. So it's a huge, huge change. Then we go on, and there are a couple of other cases cited in the paper, and because time is running short, I'll go ahead and try to wrap up. 2011, we have probably the fourth or fifth case come out. Now keep in mind, it started in 2005 with Cortez. You can go back and maybe not even find a case in Texas jurisprudence written on about Voir Dire by the Texas Supreme Court until 2005. And then since then, we've had like roughly 5 cases. A lot of attention all of a sudden. And it's toward giving the trial court discretion. The latest case is in re Seth Hill. It was a mental commitment hearing, a civil hearing, in which the state had to prove that this Hill person engaged in abnormal sexual activity, and second prong is that he was likely to continue to engage in abnormal sexual activity, abnormal violent sexual activity. Well, he had been an inmate in an all-male institution. He admitted that he had sex with other male inmates. And apparently, the civil commitment proceedings were brought because of his deviant behavior. Overall, I don't know all the details opinion didn't state all the details. And I say deviant behavior because apparently there was some violent behavior that was part of it, but the opinion didn't go into detail about the violent aspect of it. So, defense counsel starts to ask about homosexual activity. And the court cuts him off. And then the counsel for the defendant then tried to ask about questions relating to the second problem that the state had to prove. The court said, no, we're not even going to go there. You're not going to ask any questions. And it was pretty clear that the judge was concerned that the panel would be busted. Now, let me digress for just a second. You're going to be in courts. I mean, when you leave law school, if you were like I was so idealistic. I thought judges couldn't make any wrong rulings. I mean, they were semi-gods. They put a robe on, and all of a sudden they're cloaked with wisdom, intelligence, a demeanor. They demanded respect. And I can remember as a brand new lawyer, I started out practicing defense law in San Antonio. My senior partner, he was head of the litigation section in what was then the largest firm, he went on to become president of the state bar. But I can remember as a brand new lawyer walking with him in the courthouse in Bexar County, and there was an older judge. The guy was probably 60-ish, in his 60s. And litigation senior partner, he was probably in his 50s at that time. And I can remember the senior partner with whom I was walking, as we're passing this judge who's coming toward us, as the civil district judge, I can remember that the senior partner said, "Hi Bob, how you doing?" And the judge said, "Charlie, how you doing today?" And I was aghast. How dare this mere human address a judge by his first name? His wife is not even allowed to do that. I could not believe it. So I was extremely naive, idealistic. That changed. So what I'm telling you now about this In re Seth Hill case is that it's pretty obvious that that judge and a lot of trial judges you're going to be in front of are much more interested in making sure they get a jury in the box. The phrase fair and impartial didn't come in that sentence, did it? They want a jury in the box. I didn't say a fair and impartial jury. And it doesn't matter whether you're plaintiff or defendant. It doesn't matter what type of case it is. You're going to run into judges like this. Now, the paradox goes back to what I said a while ago. At least for the urban counties, Harris County, how many civil trials on an annual basis? 12, one a month on the average. 3 in Bexar County. Most judges now have extended periods of time of motion practice interspersed with a few trials. And it used to be just the opposite. The vast majority of the judges' time is spent hearing motion documents, ruling on summary judgments. Very little of their time is spent in trial, relatively speaking. So that's the irony. So little of their time now is spent with lawyers in trial picking a jury, which is a misnomer, compared to sitting in their chambers or hearing motions from the bench. But they're concerned that they're going to be getting behind in their motions. And so guess what gets sacrificed? And I think that whether you're plaintiff or defense lawyer, I think people would agree with me on that. I'm talking generally. I'm not trying to paint every judge in Texas with this broad brush, but there are a lot, and you will appear in front of many of them. So just be prepared. Jury strikes, I mentioned that in civil district court. Well, let me go back to the Hill case, finish up real quickly. Judge said, no, we're not going to go there. Texas Supreme Court came out with a per curiam opinion. Said, no, he should have been allowed to ask because this is a legislatively mandated burden of proof that the state is required to prove, and the defendant should know, be able to inquire about these subject areas that the burden is on the other side for. Now, to take what you take out of that case, if you're going to look at these cases collectively, I think you can take out of that case, I think, that if, as long as you tie your questioning to a claim or a specific defense, and you use that as the justifiable reason, the rationale, and you show the judge the in re Seth Gill case, I think you're going to get a lot farther down the line in being able to go into that line of questioning. If you just try to go into, well, would it make a difference if maybe Sylvia was unbelted? And that's it. The judge may well shut you down. They may well shut you down anyway. But if you had said at the bench, Judge, I need to go into this because there's an affirmative defense of misuse of the product not being belted. It goes directly to the heart of the defense that I have to face. Something along those lines, on the record, even when you go up to the bench, make sure that the court reporter is still taking down what you say, because a lot of times you'll go up to the bench, counsel approach the bench, and the court reporter will be over there, and you'll go over here for a bench conference whispering. The judge will cut the microphone off so the panel members can't hear. And guess what will not end up on the record? These are little tidbits that, I don't care how experienced you get, are often overlooked by lawyers because you get into the heat, you get caught up into what's going on, and you forget about that. So, all in all, we have a sea change of Voir Dire in the last less than 6.5 years, like we have never experienced ever in Texas jurisprudence, on a very important part of the trial that cannot be underestimated because, as I said at the beginning, I don't care how strongly you feel or how excited you get about that smoking gun document or the admission that you're going to bring out on cross-examination. It all has to go through the filtering process of the life experiences of those people and what you want to do. 90% of your objectives should be identifying those individuals whose life experiences, whose beliefs, whose backgrounds are not going to be compatible with your claims or defenses, with the facts of your particular case. So, I wish all of you the best of luck. I think I was only given 2 hours today. No, I think it was just an hour, and I think a lot of you guys have class or other activities to go on to, so I've already overextended my stay a little bit. But I appreciate your patience, and I'm excited for you guys. I really am, because it wasn't that long ago that it seems that I was in your seats, and I was very active in Board of Advocates. I was president of the Board of Advocates in law school, and I can remember helping to organize those moot court competitions and mock trials, and getting grades for advocacy class and things of that nature, and it helped. It really did. So I applaud you guys for being on the ground floor, and I truly hope, I truly, truly wish with all my heart that you will have the opportunity to get experience in trying lawsuits to juries. Thanks a lot.
One of the things I did, I guess, mention about Mr. Laird earlier is that he's likewise a member of the ALI and continues to give back to legal communities in ways that we don't even know and we will never even see. So we are very, very grateful and thankful for all that you do, sir, and hope to have you come back yet again.
This isn't more food, is it?
Yeah, there's a combination of food and other stuff in there, and little coffee cups and stuff. But I'll make sure to get all of you a packet if you do not have one of the Voir Dire packets. I still have mine from last year, and I flip through it all the time. It's an outstanding piece of work by you, sir, so thank you for imparting your wisdom on us. So. Yes.
somebody's meeting.
I have to hold the other, so all good. I told you.